welcome to the Empower Together Navigating Legal Changes in Response to COVID-19 webinar series presented by the LevittQuinn Family Law Center and the Reape-Rickett Law Firm. My name is Sarah, and Anastasia and I will be assisting in today's webinar. So joining us to discuss our topic today, the impact of the CARES Act on support, divorce, and retirement, are LevittQuinn attorney Nalleli Sandoval and Reape-Rickett attorney James Reap. Mr. Reap has been practicing law for over 35 years and has served as judge pro tem and mediator for courts across Los Angeles County. In addition to his extensive experience, Mr. Reap is a member of several legal organizations, is involved in the business community, and other nonprofit organizations. Ms. Sandoval is the staff attorney and community engagement coordinator at LevittQuinn. When not assisting her clients, Ms. Sandoval works to connect legal information and access to underserved communities. This afternoon, Mr. Reap and Ms. Sandoval will discuss how the CARES Act affects family law issues, including support, divorce, and retirement funds, as well as an update on the status of court functions for Los Angeles and Ventura counties. They will review eligibility for the stimulus check and dependent tax credit rebate, accessing retirement funds, and the impacts on divorce and support. Finally, Ms. Sandoval and Mr. Reap will address questions submitted by our audience to help you navigate the current situation. We encourage you to submit your questions during the presentation, and we'll address as many as possible, time permitting. Please note that we are unable to address case-specific questions or information, so please do not submit personal information. Also, the information presented in these slides, along with the links, will be sent to you after the webinar for your review and reference. To get us started, Ms. Sandoval will review the status of the family law courts.
Good afternoon, everyone. Thank you for joining us. Before getting into our topic for today, I wanted to give you a short rundown of some of the things we've discussed in our prior webinars regarding the status of the courts. In Los Angeles, the courts reopened on June 22nd, 2020. The court is now accepting and processing all filings and will begin to conduct hearings on all matters, not just restraining orders and emergency orders. But please keep in mind that the court is backlogged, and they have prioritized the way that they're going to take on hearing these matters. More information on this will be given in the next slide. Just because the court is open, it doesn't mean that everything is back to normal. You essentially can't walk into the court without an appointment of some kind. Even to get a copy of your court file, you need to call and make an appointment beforehand. To file something new in Los Angeles County, you can do so through mail, fax, and the drop box located at the courthouses. And I believe that at Mosque, the clerk's office is open, but they are only allowing in 4 people at a time at the most. Also, in Los Angeles, if you're filing an ex parte or a restraining order, you can file via email. And we will have that email available for you in one of our resource slides at the end. When it comes to appearances in Los Angeles, there are a few options. It can still be done in person, but it can also be done remotely by court call or WebEx if you're in Department 18 or 22 of the Central Courthouse. The court also plans on using something called Court Connect, which will eventually take over court call in August of 2020. Now, the court highly recommends using one of the remote alternatives if you have an upcoming hearing to keep everybody safe. Moving on to Ventura. Ventura actually opened on June 9th and resumed functions on June 15th, 2020. You can now file anything related to family law in the court, not just restraining orders and emergency orders like in the prior months. To file something, you can do so through mail, e-delivery, and through a drop box located at the Hall of Justice. And for restraining orders and ex partes, you can file via email. Again, we'll provide that for you in a later slide. Lastly, in Ventura, appearances can still be done in person, but they can also be done remotely through a conference call. It's important to note that both courts still have no child center, waiting rooms, or anything relating to taking care of children, so keep that in mind if you plan to appear in person. In general, all of the courts are abiding by social distancing, so expect that the court is going to look different, at least for a while. There will be no hanging out in halls, you will be expected to wear masks, and it'll be like that for the foreseeable future.
Well, good afternoon, and again, thanks for joining us. So we talked about the court prioritizing matters. What we know from Ventura County is they have not really mentioned anything about it. So our assumption is that each of the judges in their particular courtroom would be looking at their calendars and prioritizing them based upon the way that they want to administer it. In Los Angeles County, however, we have been told by the supervising judge that the backlog has been triaged into 4 categories. The first category being the most urgent and basically mirroring the type of hearings that took place prior to its opening again on June 22nd. So the staging for these hearings is in category 1, we have continued restraining order hearings, post-arraignments regarding contempt, something called a Family Code 3130 request for order, which is basically a district attorney seeking out a child or trying to bring the child before the court, disappearing in a custody case, international kidnapping, and hate convention matters. So those receive the highest priority, and those the backlog of those will be taken care of first. But the way that this is administered in Los Angeles County is it is up to the particular judge in the courtroom to triage their own caseload, so that it would not be unusual for one judge to be doing category 2, 3, or 4 matters earlier than other judges. What we have been told is that the date that you have notice of currently and the date that you can find at the LA court online is the good date. You should expect that that's the date that your matter is going to go and prepare accordingly. So the next category of urgency would be initial requests for custody orders, support, and/or attorney's fees. What a judge in their department believes to be an urgent request for order, child custody modifications, and the default trials, which is one party is not in the case, so they're relatively quick and easy to administer. Category 3 would be all of the requests for orders for modifications of a custody or support orders. Category number 4 is everything else. So with that said, the question arises, so when is my hearing going to take place? Number 1, check the court website. We believe that that date is the accurate date. We're seeing things. I have personal knowledge of a category 4 matter going forward on the first day of opening. And my firm's experience is we're starting to see dates in July, August, September, October for anything other than what I would say would be the trial of the matter. We haven't seen anything related to real trials as of yet. In fact, any trials that I had set were vacated and set for a case management conference instead.
Getting into our topic for today, I want to discuss what the CARES Act is and what it does, because it is the overarching theme in our webinar for today as we discuss some things like stimulus checks and child tax credit rebates. Even if we don't get into every facet of what the CARES Act does, we want to let you know what it is. So what is it? For those of you who don't know, it is the Coronavirus Aid, Relief, and Economic Security Act that went into effect on March 27th, 2020. It was set up to help people financially during this pandemic. The CARES Act includes funding for businesses, direct assistance in the form of a stimulus check, which most of us have received, and which we'll talk about more in depth, and expanded unemployment benefits, like increasing the amount of unemployment that one is eligible for during this time. While the CARES Act provides financial assistance in a variety of ways, what we'll be focusing on is the stimulus checks and the child tax credit rebate associated with those checks.
So let's talk about the stimulus checks. As most of you know, the check is $1,200 per adult, but there are certain limitations. So first is, understanding that this is basically set up through federal tax law. And the stimulus check is a credit against the 2020 taxes that may be owed. And it's important to note that unlike other types of tax credits, that this is not reduced should you have past tax debts, either state or federal, that are owed, or student loan payment debts that are in arrears. However, in certain circumstances, the stimulus check can be offset by past due child support. And what I mean by limited circumstances or certain circumstances is that applies only to orders that are being enforced by a local Department of Child Support Services. So to get your stimulus check, what you need to do is make sure that you file a 2019 tax return, which is now currently due by July 15, 2020. To receive the check, you would get $1,200 filing as an individual with an adjusted gross income of $75,000 or less. If you file as a head of household with a dependent, then you get a maximum of $1,200. If you earn under $136,500, down to you get the full $1,200 if you earn $112,500 or less. The other is married filing jointly, and the income qualification there for $1,200 per adult or a $2,400 max is an adjusted gross income for the couple of less than $198,000, and they get the full $2,400 if their adjusted gross income is less than $150,000.
Now we get into a little bit about the dependent child tax credit rebate. For those of you with children who received or will be receiving a stimulus check, there is a dependent child tax credit rebate to consider. There's an additional $500 rebate available for any child who qualifies for the child tax credit. And in tax terms, a child is a dependent of a taxpayer who is under 17 years old. So if your child is 17 or 18, they're not eligible for this credit, this rebate. Now, who gets the rebate? That really depends on the parent who claimed them in 2019. For the parent who prepared the taxes in 2019 and claimed the child, the rebate check would go to them. Now, if in 2019 nobody filed, then it would be based on 2018 taxes. If neither parent has filed in either 2018 or 2019, you actually still can get the stimulus check with the child tax credit rebate if you file before the end of this year, 2020. For those of you who had children born in 2019 and 2020, there are some things to note. If your child was born in 2019 and you have not filed, you actually still can get the child tax credit rebate so long as you file before the end of this year. Now, if your child was born this year in 2020, you are still eligible for the rebate of $500, but you won't receive it until you file your 2020 taxes, in essence, that being in 2021.
So, what about the recent divorces? We have to look at this and understand that, again, this is really part of tax law, which is technical rather than equitable. So it's not based upon fair. We're also talking about $500 per child. So that's not an amount of money that should be forcing somebody to go to court. And it's certainly not an amount of money that's going to get the interest of the judge to determine how the funds are going to be divided. But let's go through what we have a reasonable expectation is going to be happening, at least with the check. So if you filed jointly in 2018, but now had your divorce finalized in 2019, and nobody's filed a return, then the check for the child tax credit is going to follow the 2018 return. So what you may want to do is make sure that you update your information. And we provided a few links to make sure that you update with the post office and the IRS to track down the instances where perhaps you're no longer living at the residence that you had in 2018 and don't have the electronic deposit. So there's an interesting thing. What about the parents who alternate years in claiming their children? Again, this is tax, so it's technical. This is a rebate credit for 2020. So legally, it should go to the parent who has the ability to claim the child in 2020. However, it's very likely that the other parent is going to have already filed their 2019 return and probably has gotten the child tax rebate associated with that. So once again, this is something that you really need to talk to your former spouse or other parent and try to work out yourself. Again, for $500 a child, I don't expect, but I can't guarantee, but I don't expect many judges to have much interest in weighing in on that kind of dispute.
Right, moving on to another topic that the CARES Act has had an effect on. The pandemic has had major impacts on withdrawing from retirement accounts like 401ks, 403bs, 457s, and individual retirement accounts, or IRAs. A lot of the penalties for early withdrawal have been eliminated by some plan providers. There used to be a 10% penalty for people who were trying to withdraw before the age of 59 and a half. But in order to qualify for early withdrawal and avoid that 10% penalty, you need to show that at least one of the following conditions exists. 1, you've been diagnosed with COVID-19. 2, you have a spouse or a dependent that has been diagnosed with COVID-19. 3, you have been laid off, furloughed, or have had your hours reduced. Or 4, you have been unable to work because of COVID-19, or you haven't been able to get childcare because of COVID-19. Now, all of these withdrawals are subject to a tax, but currently it can be spread over the length of 3 years. And actually, if you repay into the retirement plan or the individual retirement account within 3 years, then no taxes will be due. It's very important to note that if you have one of the above conditions and you're considering early withdrawal, before assuming that this applies to you, you need to check with your individual retirement plan provider because it's not required for any of them to adopt these new rules.
Okay, so the other way to get access to your retirement plan savings is through a loan. And it's always been the case in the past that you were able to borrow 50% of your vested balance, not to exceed $50,000. The CARES Act enhances it and allows you to now borrow up to 100% of the vested balance, but again, not to exceed $100,000. There is a 5-year repayment plan for paying it back, and a benefit that you get from the CARES Act is that that won't start until 2021. So in effect, gives you until December 31st of 2025 to repay what you have borrowed. If by December 31, 2025, you haven't paid back the loan and the interest, then the amount that hasn't been paid back will become taxable income. Important to note the enhancement, so the ability to borrow more than 50% or to borrow between $50,001 and $100,000 is limited to those people that have been affected by COVID-19 under the same plan as Ms. Sandoval had just gone over relating to the withdrawals.
Some of the things to consider if you are getting a divorce at this time is, along with the rules and the regulations for taking out a loan or the withdrawing, there could be some positives and there could be some negatives. Now, one potential positive, if you are going through a divorce at this time and you qualify for the early withdrawal, it could help for settlement purposes, like being able to divide that money now rather than at retirement age. But of course, on the flip side, there are negatives. There could be people who try to withdraw early for their own advantage. Now, in the state of California, if you've already started a divorce, then you have what's called the automatic temporary restraining orders in effect. These restraining orders essentially stop anyone, either party, from transferring or encumbering any property. So to do something like this would be a violation of those temporary orders. And one last thing to know, if you are currently separating, the stimulus checks that you guys have received during this time are considered community property.
And that wraps up the presentation portion of today's webinar. Mr. Reape and Ms. Sandoval will now address questions submitted by our audience, starting with those submitted during the registration process. Also, please feel free to submit your questions via the Q&A feature, and we will do our best to answer as many as possible, time permitting. Again, please do not submit any case-specific questions or include any personal details, as we aren't able to address those concerns in a public setting. So our first question will go to Mr. Reape, and that is, my ex and I alternate years to claim our child as a dependent. My ex claimed our child for 2019 and has already filed their taxes. Will I be able to receive the $500 rebate?
I addressed this earlier. So what's going to happen, in my opinion at least, is that the $500 rebate is going to go to your ex based upon the 2019 return, regardless of the fact that the $500 rebate is really a credit against the 2020 tax year that you would have the dependency exemption. This again is really $500 per child. In and of itself, I don't think that it warrants taking the matter to court, but it certainly does warrant some communication with the other parent to discuss how that money should be divided. Again, being taxed, it's technical, but it doesn't stop you and the other parent from doing something that's fair or equitable.
Thank you, Mr. Reape. We're going to move on to our second question, and this is for Ms. Sandoval. My ex is in arrears and owes me child support. Will I receive their stimulus check?
So you directly will not receive the stimulus check. A stimulus check can be offset. One parent who's not paying their child support can have their stimulus check reduced by past due child support, but only if it's being enforced by the Child Support Services Department, as Mr. Reape earlier outlined. Now, having an agreement for child support or even a judgment that's not being enforced by the Child Support Services Department is not enough, and it doesn't entitle you to that other person's stimulus check.
Thank you, Ms. Sandoval. We'll move on to our third pre-submitted question, and that is, if I've already been served for my divorce, can I withdraw from my retirement account to try and create a settlement?
Well, you could, but as Ms. Sandoval had indicated, absent an agreement with your spouse or an order from the court, that would clearly violate the automatic temporary restraining orders. So what I suggest that you do is that if you believe that this is something that's a benefit to you and your spouse, is to discuss it with them and indicate exactly how those funds are going to be used or how they're going to be divided, and see if you can get an agreement. Now, if you're on the other side of this question and you're concerned that your spouse is going to make a withdrawal from their retirement account and they're not going to respect the automatic temporary restraining order, what you can do is serve on the administrator of those retirement accounts something called a notice of adverse interest. You're basically just letting them know that there's community property in the retirement accounts, that you're going through a divorce. And what they administrators will do is they will put a freeze on the account that would prevent any withdrawals or loans from being taken.
Okay, thank you, Mr. Reape. Now we're going to move over to the Q&A, see what questions we have submitted, and see if we are able to answer those questions. So we're going to give Ms. Sandoval and Ms. Reape just a moment to review those. Thank you for submitting those questions to us. I do have a question here that looks like it came in separately. Ms. Sandoval, do you think you'd be able to address this question? I was able to relay in the chat function.
Absolutely. So the question is, if I have a minor child who turns 17 this year, would they be eligible for the rebate that we had talked about earlier? Now, unfortunately, you wouldn't actually receive the bonus, the rebate, excuse me, the child tax credit rebate. If you know, going back to what I said earlier, that credit is for children who are, or dependents, excuse me, who are under 17. So actually, if your child is 17 or 18, unfortunately, they would not be able to receive this.
Thank you, Ms. Sandoval, for answering that question. If there's anyone else who would like to submit a question via the Q&A function, we do have a little bit of time available to answer maybe one, maybe two questions regarding the CARES Act and retirement, support, the stimulus check, etc. So please feel free to use that Q&A function. And we'll give another moment here for questions.
Is this a good time to go into the pending legislation?
I would say so.
Go ahead.
All right, so I know that quite a few of you actually submitted questions on the HEROES Act. And we don't want to give you any information about that now because while it was passed by the House, it now sits on the Senate's calendar. So it still has kind of a long way to go before it actually becomes law. If that were to be the case, if the HEROES Act does eventually get passed, we would be happy to do another webinar where we break down you know, the benefits, what it entails and things like that. But at this point, it's not law. It is still with the Senate. So it would be, you know, it's got a long way to go.
Thank you so much, Ms. Sandoval, for addressing that. I did note there were a couple of people asking about the HEROES Act. So hopefully we'll have some more information on that, as you stated. And again, thank you for submitting your questions and for joining us to review the impact on the CARES Act on support, divorce, and retirement. We hope the information provided was empowering and will help you navigate family law issues during this health crisis. In the event you have case-specific questions or concerns, you can contact the LevittQuinn Family Law Center or the Reape-Rickett Law Firm via the information provided here. And we've got our website and phone numbers available. And again, we apologize if we weren't able to answer your specific question. And as Nalleli and Ms. Sandoval had mentioned, we will follow up if additional information becomes available regarding the HEROES Act. And we look forward to providing that information.